Okay, hello everybody. Thank you for coming. It's a pleasure to have today with us for this CIPIL evening seminar, Dr. Alina Trapova from UCL, University College London. Alina is a lecturer at UCL. Previously, she was an assistant professor at the University of Nottingham. Before that, she wrote her PhD on machine learning and EU copyright law in Italy at Bocconi University. And that is precisely what she is here to talk to us about today. She will be talking to us about generative AI and copyright law, as you can see on the screen. I know Alina from working together as co-managing editors at the Clua Copyright blog. Alina, it is wonderful to have you with us here today. I am very excited about this presentation. So, but on that note, the floor is yours. Look forward to hearing your talk.
Thank you. Thank you very much, Christina. And thanks a lot to CIPIL in general for the invitation. And it's really, really nice to be in Cambridge and to be yet another person on your radar talking about generative AI and copyright law. This has become huge in the last, I want to say, for me, it's since 2016, since 2017, I decided to go into a PhD on this topic and then remain in it. But before I go into the substantive part of my talk today, I'd like to, first of all, say a few things about something that we're organizing at my institute, at the Institute of Brand and Innovation Law at UCL in June 2024. We're organizing a PhD conference. For those of you who are, I'm not sure if we have anyone here, but I just wanted to flag it, an IP PhD conference where we're really trying to inspire PhD students. So this is mostly targeted at people during the second year of their PhD who have completed at least first year. And when our energy and enthusiasm about research goes down and we start questioning, should I not have actually become a lawyer? What am I doing with my life? So anyway, I wanted to flag this, and it's a great opportunity for people doing research because we will be doing tailored feedback on individual papers. Now, going a little bit into the big thing today. So last week, I had the chance to visit an exhibition in Paris. And this is a little bit of the things that I actually saw there. This sounded a bit general when I saw the exhibition. I went there with some friends, non-lawyers, but it was basically a very interesting exhibition on our multiple personalities in the digital age. Obviously, as you would imagine, everything was about generative AI and digital cyber and everything that is taking us there and actually allowing us to have different personalities. Now, one example I wanted to show you from this, because we talk about all these systems and we use the same examples, and I actually talking about copyright, human authorship and originality, I thought what I saw there was quite impressive and very good introduction to my talk. So this is a project by 3 artists from this collective. They used generative AI, and they entered 7 texts from antiquity describing the 7 wonders of the ancient world into a Gen AI software. Now, the 7 images that were generated were then given to a painter, to a human artist, who did something with them, who altered the pictures using oil paint, so very traditional methods. And eventually this was put on display where with the help of a tablet, visitors of the exhibition could actually experience these images in an augmented reality fashion. Now, this was nothing more than just a way of pushing us to think about art nowadays and where have we come to from the human to the machine, from the machine to the human, to our physical space, and to our perception and interaction of these things. So these are two of the paintings that were there. There was only two, even though I suppose they generated all seven and interacted with them. And as we are by now a little bit used to all of this artistic reality, they were signed with the algorithm. So this is a little bit, oh, I really hope this works. I should have tested it. Oh, this is a little bit how it works. So you would hold the tablet and you scroll over it and you see how this augmented reality, basically, the clouds move, and once you drop it, this reality is gone. And this is a little bit about the other one. Beautiful, very impressive, but it kind of also pushes us to think a little bit about what is coming out of these systems and how actually artists interact with them. Okay, the industry is very active on this. These are just some of the companies that have engaged in generative AI and usually text to image generation. I will give a few more examples and explain a little bit what basically they have done. Some of these are more familiar than others, but every day there's a new one that comes around, and every day there's a new one that actually generates different sorts of output, not necessarily just images, but also sound, code, and on top of that, litigation has started emerging here and mostly in the United States. Now, a little caveat to my talk, there's a lot on this topic, so I will definitely not be able to cover the EU, the UK, the US, input, output, and all of these technologies. So I've been a little bit selective. And I will focus on the input questions of this discussion, and mostly on the UK and a little bit on what the US has done. I don't think we will have time for the rest. I'm happy to take questions on the output as well, and on the EU afterwards. Now, the examples and the fun we can have with all of these systems is endless. This is something that was generated with Midjourney yesterday when I was browsing through its different channels. Usually the way these systems work, these prompt engineering technologies, some of you may be more familiar than others with that, but very, very simply explained, there's a prompt given to the system, usually in the form of a text. It could be short, it could be long, it could be pages long, it could be done several times. And then the system spits out an output. The text to image ones, mostly, so the ones that I will be mostly talking about are text to image generators. And the prompt here was a colorful painting looking over the shoulder of an astronaut looking out at a colorful galaxy. Nothing controversial, I would say, at this point from a copyright perspective. So very, very handy and useful. The breakdown of the whole process, again, rather simplistically, would involve a prompt, an execution stage, which usually is rather quick, several seconds, where the training material is scanned. As a user of these systems, we're able to tweak to a certain extent the settings, so the style, the ratio, and to basically give some sort of parameters to the system, even though these parameters are predefined by the limitations of each of these. And eventually there's an execution stage. Now, things start getting a little bit more interesting here when, of course, now we're talking a little bit more about the input aspect, but when we start giving prompts related to copyright protected material. Now, one of these examples I generated for my students a couple of months ago was generate an exact image of Donald Duck in Keith Haring style. And we may have a discussion as to whether this is actually an exact image of Donald Duck, but it does evoke very much Keith Haring's style. If you have seen a little bit his works, you will recognize certain features. And this is another one, an image of Snoopy on the Statue of Liberty eating an ice cream. These might be very fun and easy and interesting to play with, but they do provoke complicated copyright questions related to the training data, especially when it comes to works that are still copyright protected. And this is where all of the discussions go towards. It's a very lively field, and a couple of days ago, this piece of news circulated the media. Stability AI is one of the big, don't want to say even big companies, because I don't think they're that big in terms of numbers, but they have been really around because they have been sued in several occasions. And their AI chief quits allegedly over exploitative copyright reasons. So he came forward saying that basically he had an issue with all these copyright protected works being used as part of the training process. So the buzz is even bigger. And we're trying to make sense of all of this from an academic, but also from an industry and stakeholders perspective. Roughly speaking, I admit that I'm not an expert on the technology, so I don't know in detail how these diffusion models work. It would be very interesting to study them a little bit more. I have engaged a little bit in a research trying to understand what is this notion of noise adding and tweaking. But for the purposes of the talk today and for my research for this paper, understanding broadly speaking the way the system works is enough. Having said that, I really am very keen on knowing how individual different models work, because I think this is crucial when it comes to actually talking about infringement and permitted uses. But for what matters here, we have input images, we have something that we call training data, amongst which we find very often copyright protected material. There is an AI generative model where nowadays the prompt engineering field thrives on the basis of a prompt given to the system. There's an execution stage where certain technical processes take place. And there's, in that moment, an element of tweaking where we might be able as users to select the settings and to add certain direction as to where this work goes. So when I told the system in the style of, in a photographic style, I have a limited number, for instance, of selected features that I can direct the system to. And eventually, when these images come out, we as users are able to, at this post-curation stage, we're able to select the image that we will be using for whatever purposes. Now, from a copyright perspective, we have two baskets of legal issues, input and output questions, very much interrelated, but they are treated separately. The tests are different and the stakes are different. The first bit concerns what I will be focusing on more today, concerns the infringement of copyright when training generative AI systems. So is there an act of reproduction? Copying is usually what is referred to in the in the UK. And if there is that an exception? Is that exempted? In some circumstances, we have an exception for text and data mining, which might come in handy. And you will see how it does not, at least for what concerns the UK. For the sake of completeness, the second bit, the output questions relate to whether what comes out is actually protected with copyright. Can you commercialize it? Can you call this your creative output as a user of the system? Who is the author? If it's not protected with authorial copyright protection, is there something called, should it be protected as a neighboring right? And how do we actually make sure that these things don't stay in the public domain? Should we do something about it? Now, during my research as a PhD, I focused mostly on the outputs. And over time, I came to realize and to believe that the input questions seem to be more important. They are related. So the liability and the protectability are really a very, very long but connected spectrum. So we can't ignore one or the other, but the process works on the basis of some copyright works going into it. And that is allegedly an infringing act. And this is where many of the cases revolve around. So I say seem to be the more important issues because, well, of course, litigation is taking place there, but the process cannot work if we don't look at the input. And for that, well, human source material is crucial. To have all of these images of Snoopy, Snoopy-like, Donald Duck-like, whatever, we need input, which is very often existing copyright works. The process, whatever takes place is actually very individual. So we have to take each system on its own merits. And there are several acts of copying that take place. Not all of these are infringing acts in our copyright systems in the UK, in the EU, in the United States. We have certain laws and certain exceptions that allow us to actually dismiss from the infringement side some of these acts. And this is mostly what I'm referring to is the temporary copies. But there's many other copies within this long and complicated process that are not temporary. And this is where the controversy lies. Now, I turn to the UK. And there is basically 4 pieces of the puzzle. Now, there is a useless provision in the copyright law in the UK where for text and data mining, and I will turn to it briefly to explain to you why it's useless. It's useless from a commercial perspective because it is not adapted for commercial text and data mining and basically what all of these companies, text-to-image generator companies, are doing. There was a public consultation not too long ago. There is litigation ongoing, and from what I understand, not going in the direction of settling. And currently, there are stakeholder roundtables taking place, chaired by the UK IP office, trying to make sense of all of this. I will mostly focus on the last bit, because this is what I think might actually produce some useful output from all of these discussions. It's not going to be the outcome of the case, and the public consultation, as you'll see shortly, didn't achieve whatever it was hoping to achieve. So, though, starting from the first bit, the useless provision, it is only, I call it useless because it is for non-commercial research. So section 29A from of the Copyright Designs and Patents Act 1988 allows making of copies of a work by a person who has lawful access to the work. And then it puts down certain elements of this exception. This is rather restrictive and not good enough for generative AI systems because it requires lawful access to the works. And there are certain definitions from the case law, from the directive from where this exception derives as to what lawful access means. But that's, let's say, one impediment to this being helpful broadly over the board for all sorts of companies. The bigger one, however, is the fact that this is targeted solely for the purpose of research for a non-commercial purpose. And finally, there must be a sufficient acknowledgement accompanying the copy. Now, this might be interpreted a little bit broadly and depending on the circumstances, but this provision came about in 2014. And in 2014, generative AI was probably a topic just for a very narrow technical field. It was definitely not on the agenda of copyright scholars and legal academics. So this was not a provision targeted at the reality, at the technical and industrial reality that we have nowadays. And if we are trying really hard, we might be able to fit in certain AI and generative AI systems within this, but it might definitely be a stretch. And in any case, this is not helpful for commercial purposes. Now, the consultation that took place here, there's two things I want to say about this. This took place from November 2020 until January 2021. And it took place in a post-Brexit reality and in a reality where AI was really, really booming. It still is booming, but the UK jumped on the train of the post-Brexit reality saying, we want to be the leader in AI. And with its AI national strategy, it actually really sought to install good and clear, so to collect all sorts of evidence in order to have a good and clear copyright and patent system so that it can become the place for these industries to come invest, feel secure, and bring in money. And the post-Brexit reality is, of course, it's not tied to the EU, complicated EU law making and its laws and the Court of Justice, so it could do whatever it wanted. The outcome was published later in 2021. But what I found interesting in that consultation to paint the background to generative AI was the, don't worry about all of this, I just want to focus on one bit. It's the accompanying impact assessment document. I think that they did a very good job in painting the big picture, the bird eye picture, as to who is a stakeholder in all of this. And the document explains the costs and the benefits for the copyright holders, for the TDM users, for the AI industry, for the profession, for the legal advisors. How is that going to basically changing these three different aspects? Because it focused on not only on text and data mining, but also on computer generated works and on patent and inventorship. It sought to paint the big picture. And the general aim was to collect evidence as to what are people doing with this and how can we make the system work better. And if you can focus only on point one there says one of the options of reforming that text and data mining exception I just showed you was in light of AI, in light of the fact that all this training material is really heavily used by these systems. One of the options on which it sought evidence was the licensing environment. How does text and data mining licensing currently work? Please tell us what kind of models you have so that we can learn from you, from your industry, and maybe come up with something helpful and useful over the board. across horizontally. Now, I don't know, I might be the only person thinking this, but reading these documents and reading that impact assessment, I had a feeling that the UK IPO was really hoping to get evidence on this, to get really evidence that they can say, yes, licensing can work in this and that way. Look, this person is doing this and that. They got nothing. Or whatever they got was very little, completely useless for the purposes of making a general recommendation. To the extent that if you look a little bit at the replies to the consultation, I picked out the BBC as an example. And this is the UK's national broadcaster, where it's not a startup. It's a rather powerful, and you would think, capable body. They said that the cost of licensing third-party data sets in their own machine learning projects is high and complicated. They listed only 3 projects in which they engaged with third-party data. For the rest, because it's the BBC and it has access to its own databases, they were in the process of actually using machine learning and text and data mining tools, but relying safely on what they had. And with respect to the text and data mining exception, they said that in the absence of guiding case law to foster legal certainty, that exception was unhelpful to form sound business model for the use of vast quantities of copyright in a single project, the BBC. Unsurprisingly, users felt that they were priced out of licensing for research projects. The models and the licenses that they had to work with were costly and unworkable. And this was not really, really a surprising stance, unfortunate. But on the basis of this consultation, the UK IP office decided that it will move forward with a TDM exception, with a text and data mining exception for all purposes. Now, you would think that someone would be unhappy about this, and the music and the publishers were genuinely very upset with that. This came a little, this proposal to open the exception so broadly came a little bit abruptly to these industries. And I understand that this was when consultations of the similar character took place in other jurisdictions. The reaction was very, very similar, and mostly by the music industry. I don't think we're very surprised by the fact that the music industry is very vocal and active in this respect. But this was also the same thing in other countries. So, having heard the big no, the UK IP office decided that this was way too ambitious and rolled back. So we had a public consultation. There were really no good evidence of it. They decided to go for something that some of the stakeholders really disliked, and then they rolled back. So no, I'm not saying that this is an easy process. I don't want to be misunderstood here. It's a very complicated task. Someone has to do it. We have to figure out, or we can stand back and do nothing. But the people who are engaging in all of this, it's not an easy task they have on their shoulders. So it's not good to just criticize the process. But the direction is a little bit, I feel like the direction is a little bit lost. So in the meantime, obviously litigation started. And Getty Images sues Stability AI here in London. And this came around a little bit after the United States lawsuits started. And I don't even know how many US lawsuits currently there are related to copyright training data, copyright protected training data. But in the UK, I think there's just one. But new ones are just mushrooming everywhere. Now, when you look a little bit at what is being argued in this case, a lot is about licensing. If not all, but a lot of it is about the money. Getty explains very well in its brief, in the statement of particulars, that it invested a lot in obtaining, verifying, and presenting the contents of its Getty databases. You have the numbers on the slides. Every year, they have put a lot of investment in actually making sure these databases are there. And they also identify in these training data sets, that Stable Diffusion 1.0 and 2.0 have been using, how many copyright works from the Getty Images website have been scraped. Because I should have mentioned this, but the basis of all of this lawsuit is that Getty Images, because Stability AI has made transparent the databases on which it trains its systems. So Getty Images basically understood that they have the works from their website have been input into the system. So from the 12 million visual assets from Getty Images in its first version, around 7.3 million, they argue, are copyright works, which are copied at one point in the process. Now, it's a question whether this is an infringing copy or not, but this is the argument that Getty is playing. The training process is briefly explained in the statement of particulars, and they argue this is infringement of the reproduction. Right. Now, I don't think they are settling, as I said, so we will have to wait and see what comes out of this case. In the meantime, the UK IPO did not just hold back and say, well, sorry, we're not doing anything. They started doing things. And these are the things that I focus mostly on in this paper. They started making some small steps in policymaking. Very important. I think it's a good idea as a policy idea. And the background to it is that the approach we have to take towards generative AI should employ a lot of regulatory flexibility and divergence. We can't take these systems as one size fits all. They are different, and they require us to engage a little bit in the technical side of it. They're promoting experimentation to support the scaling of these technologies, and they're very conscious that this is not going to be within one territory. This is no longer going to be the issue of the UK only, obviously, since digital, everything is international. So the hope is that eventually there will be some sort of international regulatory harmonization for these established technologies. I know this sounds very broad, but I'm getting a little bit more specific with the next bits. They are attempting currently to work on a code of practice. So, code of practice, which is going to be voluntary for the industry, and it is hoping to be this sort of multi-regulator AI sandbox, so a lot of open-mindedness in how this can work, and to take a clear policy position with regards to the relationship between IP and generative AI. Meaning it's supposed to basically ensure access to works, while at the same time protecting right holders and protecting the interests of copyright holders. This balance that we always talk about in IP and in copyright in particular. The balance between the right holders and the users, the fact that every legislation should be inclusive and take into account not the fact that we just need strong rights, but we need also equally good exceptions and so on and so forth. The proportionate legislation that we like to talk about. So we have these attempt for a code of practice, a working group was set up during the beginning of the summer, around May, I think. And you have the names of the members of the working group. All of this is publicly accessible on the UK IPO website. So you have a mix, we have an interesting mix of a lot of trade bodies representing different industries, from photographers to music, through the library, many trade associations. Most of them, if not all of them, UK trade associations. There are some private stakeholders. You see DeepMind, IBM, Microsoft there, Stability AI. I wonder if they would have been on the list had they not been in court just a little bit before, a year ago, because Stability AI was born as a company last year in August. So now, I would say slightly random private bodies, but obviously you want the IBMs and the Microsofts to be there. There are some advocacy groups advocating for the interests of the startup industry, for the entrepreneurs. I saw this and I thought, how did I miss this? How did I miss that there was a call for interest to be part of this working group membership, and to basically sit down on these tables and come up with this nice code of practice, which we all want to come up with, or at least listen to these discussions as an observant. And then I realized that there was never a call for this. There was never an official call for interest, for participation in this working group. So in my point in this is, some might think that it's minor, but I think the transparency and the inclusivity of the process in making this is really flawed if we have a membership group that is just selected by the UK IPO in that respect. I know many of these groups, many of these bodies, they reply to the public consultation. They are involved in litigation. I don't think Stability AI replied to the consultation, but they are in court, so they are interesting to have on the table. There is a body, a membership body that lobbies on copyright policy matters and has mostly academic researchers there. That's Copyright for Knowledge. But had there been a public call, maybe me and Christina would have participated in it. We would have said, or not me and Christina, but someone else, someone who wants to sit there. So I thought, where are the academics? I mean, we create a bit of problems most of the times, but it is healthy to have these different voices. And there's a lot at stake here. This is not just any public consultation on any matter. This is on generative AI. There's lots of things going on. So to me, the process in this policy making is really questionable. And when it comes a little bit to these code of practices, then we need to question a little bit. So what is going to be the output of this? Is this going to be a non-legislative piece of output? So the code of practice that's voluntary, non-binding. So maybe you don't need to be as inclusive and as open in the participation. Is it going to be quasi-legislative? So if the intention is that this code of practice is eventually going to be adopted by the industry, and it most likely will if you have IBM, Microsoft, and generative AI companies such as Stability AI, and as well as the trade bodies for the right holders sitting on the same table and agreeing on something, it's really illusionary to say that this is going to be just a voluntary code that if you want to adopt, you adopt. I mean, that's, to me at least, that's going to be the case. So there's a bit of a question mark as to whether there is a legitimate expectation for a formal consultation on the code before it's actually disseminated and adopted. It's a targeted informal consultation, but the tasks and the aims it puts forward for itself. So making licensing for data mining more available, and overcoming these barriers. These are all things that we are struggling with, regardless whether that's in court, in lawmaking, and or in industry, or with your lawyers. So that's a bit of a flaw in my view. Now, I know I'm conscious of time, so I can move a little bit to the US and then stop and have a discussion. But the tasks are still, this is all from their terms of reference, all the things that we have on display on the website. The tasks are good, are clear-ish. So you need to identify the creator's concern, identify the barriers, and set out commitments and expectations, taking into account all of this. I think this is good, but probably not enough in terms of legislative process making. Now, to compare a little bit, the same type of questions with what the US is doing. True, the US is much bigger. It has a lot more voices to take into account, only with respect even to trade bodies. But the questions that the legal issues in terms of copyright they face are the same, even though the legal systems slightly differ, and their fair use doctrine works differently. But the technical AI reality is similar, it's the same. Now, what the US did is that they had a public consultation as well. And that one received, I think, nearly 10,000 replies. It closed earlier in the year, it closed in October. They extended the deadline once. Now they've extended the deadline one more time. And having received certain input from the interested bodies, they held something that they called listening sessions. So during the spring of 2023, they held 4 listening sessions with 90 participants and roughly 4,000 viewers. And all of these listening sessions were targeted at a different aspect of the creative industry. So one for music, one for photographers, entertainment industry. So they probably are doing it a bit too much, because I spoke to someone in the US Copyright Office recently, and they have really overwhelmed with statements and all sorts of wanting to speak academics, such as myself, sent them their opinions. And that may be a bit too much when you have 10,000 replies to go through. But it's very transparent, but it includes everyone's view. They've also issued a registration guidance, but this is a little bit more on are these works protected or not? So I think in terms of process and inclusivity and transparency, there's a lot that can be taken from what the US Copyright Office has done, is currently doing, and maybe replicated here. But I would like to finish on this and have a bit of a discussion. So I'm definitely not going to go through the EU, also because the word AI Act is a little bit controversial at the moment, politically, I understand. So thank you, and I'm happy to take questions.